your submissions has to be done in this order, has to include this or has to include that. Okay, all these things is the procedure. This is just one example. Okay. Then after that, there is a relationship between not just the two disputing party, now include the third person called the adjudicator. So you got to change name. There's no such thing as a non-paying party anymore. There's no such thing as unpaid party anymore. The unpaid party now become claimant. The non-paying party become respondent. So this is the time when the name has to be changed. Okay. When there is an adjudicator, you have got 10 working days to submit in what we call adjudication claim. Within the 10 working days, if you fail to submit the adjudication claim, the entire adjudication will be called off. Okay, so you have got 10 working days for the claimant to submit the adjudication claim. What does it mean to submit the adjudication claim? That means to say you serve the adjudication claim to the respondent, copy to the adjudicator. You don't serve it to the adjudicator, copy to your respondent. Not like that. You have to serve it to your respondent and then copy to the adjudicator. Okay, so this thing has to work within the 10 working days upon the acceptance of the adjudicator. So the moment the adjudicator submitted his Form 6, that is the starting time. You have 10 working days to submit your adjudication claim. All right. Now, in the adjudication claim, is actually almost the same as what you have put in your payment claim, but then it has got more detail. In your adjudication claim, you're supposed to describe why you are supposed to be paid, the reason that you are supposed to be paid. You have to build a case, or sometimes you also have to bring in your evidence, other evidence that put inside, okay, and things like that. So this adjudication claim has to be submitted together with a supporting document. This supporting document is actually your evidence, okay. So item 2 states that you provide the adjudicator with a copy of the adjudication claim together with any supporting document. Okay. A case in mind. This is very important. The way you draft the adjudication claim is very important. Usually, you have to let the adjudicator or the knows that there is this party in the dispute. For example, in this case, is an architect. Okay, so the claimant is an architectural consulting firm. There is a registration address. There's a business address. Okay, and this consulting firm must be registered with the court. So this establishes what we call it a locus standi. That means to say you are legally qualified to discharge this responsibility, and you are legally qualified to accept the fee, okay, from your client. Then you also have to identify the respondent, who is respondent. Okay, in this case, this respondent is an engineer, you know. They do what we call, they do things like consortium. You know, this project was brought in by engineers, and then they engage the architect. So unfortunately, this engineer did not pay the architect. So this is where the problem comes in. Okay, so both of them are addressed or is considered as parties. Okay, next. Now, the case. Okay, a case in mind. You have to also correctly consider or name the contract. Okay, in this case, the contract consists of 3 fee proposals. So you have to list it down A, B, and C. So together, collectively, the 3 proposals is one contract. That means to say these 3 proposals must interrelated. If it is not interrelated, it cannot be considered as one contract. There are case law on this thing. And then it must for the purpose of a project. So you have to state it very clearly. And all these things has to be proven that it has been properly accepted by the respondent. So contract, there's something called offer acceptance, right? So you have to demonstrate that this contract has been duly accepted. Okay. Then in this case, it's the Architecture Services Consortium. At the time, it consists of the 6% SSD and all this thing. Okay. And then you also have to give the relevant extract of the contract. For example, payment schedule. Very important. You have to put in the payment schedule. You have to let the adjudicator know that when it's timely to be paid. So you have all these things in. Okay. Then you have to describe the background relating to the claim in dispute. For example, you have to say that, oh, this one is actually a design and build project. That's why you have all these things. And the project at this moment has been completed. Borang F has been issued, or Borang CCC has been issued, or phase 1 and phase 2, for example. And then you see that sometimes there is some explanation, further explanation needed to be done. For example, you have a sectional completion. Okay, so these are the things. And then you have to show that this is the invoice date, the date, the due date, and also the amount. Okay, and unfortunately, this is not paid. That's why you put in all the schedule. Is it schedule 4? These are all the supplementary documents to prove that point. Very, very important. Okay. Then we always do a summary. And okay, Mr. Adjudicator, having said that, I summarize these are the total amount of claim for this adjudication. And remember, this adjudication claim, this amount cannot exceed your payment claim. It should be the same as the payment claim. If you exceeded the payment claim and whatnot, or even below the payment claim, then you are in trouble. The whole thing can be disqualified. Your whole adjudication claim can be disqualified. So you have to keep that in mind. Then you have the relevant contract provision. You have to tell the adjudicator, this is the claim based on these relevant clauses. This is interesting. This is another case. You see, the adjudication can be derailed if the adjudicator do not look at the provision in the contract as indicated by the party. He pandai-pandai go to the contract and find out other clauses within the contract and say that because of this, therefore he has to pay him how much. Cannot. The adjudicator hand and feet are tied to the clauses that is pleaded by the parties. If the party did not bring out these clauses, the adjudicator cannot pandai and go and comb the whole contract and decide on his own which is the better clause to claim this money. It happens. This case, right? Although I personally do not agree with the majority decision, the federal court decision. I don't quite agree with the federal majority decision. I'm more inclined to agree with the minority decision. Unfortunately, that is the case for this moment. It's a federal court case, so this is everybody is bound by this decision. All right. All right. So in your adjudication claim, you must also give a description about the entire process. This one, payment claim was submitted when, if there is any payment response, and when is the notice of adjudication served and whatnot. Okay. Then the nature and description of the dispute, you have to tell the adjudicator how your dispute come around. This needs a little bit of cerita, but not cerita dongeng. Okay. This must to be based on facts, factual cerita. So you have to say that usually the claimant is engaged to perform this, and the claimant has completed this, and the claimant has submitted this. After the expiry date, notice has been given, money is still not coming, therefore the dispute arises. Something to that effect. Okay, so you have to give a cerita, factual cerita. Okay, you cannot just simply give you call it a fictional story. Then this is something that we do extra. This is not necessary, but something we do extra. This is to guide the adjudicator into thinking along our mindset. So what we do is usually we help the adjudicator to frame the question, the legal question. So in this case, for example, whether the respondent has the right not to pay the work done by the claim. So it's these are questions that we want the adjudicator to think alike, like us. We put it there. Okay, then we answer these questions the way we make it logical. We've done this. Everything has been fulfilled but not being paid. Okay, so these are the things step by step we have to reason our position. Very, very important. Okay, we are not. This is not something about a theory of architecture or theory of engineering. We are not going to show all kind of calculation and whatnot. This has to be annexed to the facts. So whichever sentence that you put in, make sure this is actually supported by the documents that you have. Okay, and now you have to also inform your adjudicator, this is what we want. We want to be paid this X amount of money. Okay, what we want. So we want to claim back all the costs. So we have to tell them, we tell the adjudicator, this is what we want. 1, 2, 3, 4, 5. Okay. Excuse me. Then we have to put in authority. That means to say some of the cases that has been decided by the court that can support our case. Okay, so for example, in this case, we quoted this case called HTC Global. And so if you dispute our money, you should inform us. If you keep quiet only, that means to say you actually agree with our claim, but yet you're not paying me. So these are the cases that we can use to support our claim. Okay, and this is the then you have to sum up everything together with all your remedy, and you have to do it in a very consistent way. So at the end of the day, like it or not, you still have to draft your pleading, almost like what the lawyer is doing. Even if it's not 100% what the lawyer is drafting, but it's close to what the lawyer is drafting. So for professionals like architect, engineer, sometimes this can be a very tough thing, you know. We engineers can calculate, can do reporting very good. Architect can draw very well. When we come to writing things like this, the problem. So better not save this money, engage a claim consultant to actually do this part of the work for you. Okay, that's my suggestion. Okay, personal suggestion only. All right. Then don't forget to sign. Okay, so you sign off this thing and then you will give a copy to the AIAC for record. Now, let's recap. So from the start of this discussion, we have discussed what's the meaning of payment claim. So 10 working days thereafter, they are supposed to give a payment response. Do they give? If yes, then still not satisfied, you submit in your notice of adjudication. If they don't give the payment response, that means to say they disputed everything. And then you have got 26 working days for the adjudicator's appointment. All right. Then after that, another 10 working days to submit your adjudication claim. So this is the recap of what we have just discussed as a claimant. Now we have to change hat again. We go into the position of a respondent. Okay. Now, after receiving the adjudication claim, the respondent will serve the adjudication response. Now, this is the time that the respondent will go into action. Usually, you know. So what happens is that the respondent will serve the adjudication response to the claimant and then copy to the adjudicator, not the other way around. Huh? Now, in the adjudication response, the respondents has 10 working days after they receive the adjudication claim to submit in this adjudication response together with all the documents. Okay, can the respondent not serve the adjudication response? Answer is yes. Okay. Then what happens next is that the respondent shall provide the adjudicator this copy of the response together with all the supporting documents. And if the respondent fails to serve the adjudication response, the claimant may proceed with the adjudication after expiry of the 10 working days. That means to say that the SIPA is like a gravy train. You just travel only. Whether you manage to catch the train or not is entirely a different story. So it will just proceed as it is. Now, in the adjudication response, what is in the adjudication response? In this case, the response came in Bahasa Malaysia. Okay, so it is stated here in BM. Okay, it says that now the adjudication response usually is the response to your claim. So you claim this, and then this response will answer to this claim. So in that claim, it says that there are three contracts, okay, between two parties, okay, the engineer and the architect, for example. But over here, the response from the engineer, no, not only the two parties, actually there's three third party. Okay, the one that actually owns that building. Because they say it's a consortium. So what happens here, you can see that the response from the respondent is that, oh no, the thing is not as simple as it is. Now you involve a third party in the contract. He is very smart. Why he responded that way is because he wants to let the adjudicator know that this contract is a tri-party contract. That means to say it's not the normal two-party. Therefore, the adjudicator cannot preside over this matter. Because if it's tri-party, there must be three persons. You see? But now there's only claimant and respondent. There's no the third person. So the adjudicator cannot adjudicate this matter. It's quite a good defense mechanism. So you can see this is how the position taken by the respondent. And then so much so the respondent came up with a very novel idea. They say that there is some the contract itself is fraudulent. Why? It has got this some part of the contract has been altered with, and in order to prove that, police report has been made against the claimant. Oh, so it's just to tell the adjudicator that now it becomes a police case. Now it becomes a criminal case. Therefore, adjudication cannot happen. Okay, very interested, very smart, the lawyer. Okay, so he's explaining the involvement of this third party and how this whole thing becomes fraudulent and it cannot be adjudicable, and it overall it goes beyond the adjudicator's jurisdiction. You see, so he write everything down in that manner, and the lawyer that represent the respondent sign off. So this become a valid adjudication response. Okay. Look at the claimant's view. Okay. Now, after receiving the adjudication response, I change hat again. Now I put back the hat of the claimant. I have 5 working days to answer the response. Last already, no more already, no more opportunity. I have these 5 working days to answer to this response. Okay, this is called adjudication reply. You start with adjudication claim, then adjudication response, then now is adjudication reply. Okay, in this adjudication reply, I got 5 working days to serve after I received the adjudication response. Okay, when I serve this, I will serve to the respondent, copy to the adjudicator. And what is inside this adjudication reply? Now, this is how it's served. You serve the respondent, you copy to the adjudicator. Okay, the adjudicator reply will further explain and prove the matter raised by the respondent. So over here, I would say that there is no tripartite contract. You look at the whole contract as it is on a good faith basis. The one who signed the contract is the architect and the engineer. There is one item referring in the contract, but that refers to another contract where the third party exists. But this is another contract that does not constitute into this contract. So you have to explain things like that. So when the other contract, there is nothing to do with this contract, it cannot be read together with this contract, for example. So you have to tai chi, So you have to explain all these things. Then you have to say that the allegation of fraud, all right, is a mischievous act. That means say he just find reason to put the spanner in the crank wheel, So if you don't say that you know how to police report, I also know how to make police report. So you make a police report against the other person, say that this guy is mischievous. They do this just for the purpose of derailing SIPA. And furthermore, in law there is something called presumption of innocence. That means that it has to be proven guilty before they say you're wrong. In this case, police haven't even investigated. They just get the report. So you can't say that you are actually found guilty of fraud, right? It cannot be that way. So these are all mischievous. These are all tactic, okay? Tactic. So you have to inform the adjudicator about this. And of course, if you say that we are now criminal, you have to prove where's your burden of proof, you see. So these are something that you also have to explain to the adjudicator. Okay, and then you not only have to explain that to the adjudicator, you have to also prove that the relevant provision, the statutory default provision relating to the dispute, to tell the adjudicator that he has the jurisdiction over this matter. So you are somehow like trying to tell the adjudicator that he has the right to adjudicate this matter. The rest is not important. Okay, and then you have to highlight the respondents in what way that he has already forfeited his right or he has already waived his right. Okay, so you have to highlight all these things. And then, of course, you have to again draw back the adjudicator's attention back to your claim. I mean, he after heard you, then he heard the respondent. His mind may be now with the respondent. You have to take his mind, bring it back to your issue. So you have to tell them, you have to quote, this is the scope of the contract. You have to quote, this the scope has been completed, and you have to say this invoice has been made, but payment is not made. Bring the whole thinking into the issue that you want the adjudicator to decide. Okay, so you do it in such a way that it becomes point one answer and so on and so forth. So answer point to point of the respondent's response. Of course, you sign, you do this formality. So this has to be done in a proper formality. That's why I say, if you already have got this problem with your case, why you want to be bothered doing all this donkey work? Might as well get your claim consultant to help you. Okay? It's quite technical in that sense. All right. So we have done the overall just now. Now we go to the adjudication response, which has got, when the adjudication response has been served, you've got 5 working days to give the adjudication reply, and thereafter 45 working days for the adjudicator to come up with the decision. All right. So now we will go to the adjudicator's view. Should we take a break? Now it's at 3:19. I mean.
Okay, Ken. Shall we take a 5 minutes break then?
Okay, we take a 5 minutes break.
All right. So we'll come back about 3:25 then.
All right. Okay.
Okay. Okay, so that's the end of our break. Welcome back, everyone. So we're waiting for our speaker. Oh, David dah ada. All right.
Okay, I'm back already.
Okay.
Just hold on. Okay, now we change hat again. We no longer wear a claimant or respondent's hat. Now we wear the adjudicator. Now, if these two parties appear before you, not they say appear, but through their paper correspondence that comes before you, how are you going to decide? Okay, so this is we are looking at, they have submitted all their arguments, everything, supporting document given. Now is your time to perform as an adjudicator. So I encourage engineers and architects to actually register with the AIC to be empaneled as adjudicator. Previously, they have this adjudicator training and examination. Okay, I think for the last couple of years they have discontinued this. The reason is because there are more adjudicators than the case that coming into AIAC. I think there's around 2,000 over adjudicators, but not every adjudicators are active. So still there are too many adjudicators around, and therefore they did not have the continue training and also examination to be the adjudicator. Is closed at this moment, and hopefully it will open back. Most of the adjudicators now are lawyers and also QSs. All right. So architects, I think in this country around 20 of us only. You know, these 20 of us, including engineer. Right. So very little from our engineering and architectural fraternity. A lot from the QS and a lot from the lawyer. I think they are at the range of 80%. Okay. Now, adjudicators view. After receiving the adjudication reply, right, the adjudicator will close the adjudication. They will say close means say, okay, enough. I heard enough of what you guys are arguing. Okay, and please give me 45 working days to come up with my decision. Okay, so the adjudication will be closed and the adjudicator will retire and then take 45 working days to come up with his decision. This is what it meant. So what is this adjudication and the decision? The adjudicator shall conduct the adjudication in a manner as the adjudicator consider appropriate and the power provided under section 25. Then subject to this subsection, the adjudicator shall decide the dispute within 45 working days. Yeah. Okay. So what he wants to do with these 45 working days is entirely his problem. And there is one issue. Okay. There's one case law. Very interesting again. One party says that the adjudicator take less than 45 working days. And the decision of the court was that adjudicator should spend a significant amount of his time to contemplate over the matter. Cannot just after 1 week receiving the reply and then come up with the decision the next day. You know, you have to ponder over it. You have to think over the pleading of the party, read through the documents, and at least use 70, not 7 significant days allocated within these 45 days before you come up with your award. Well, this is a very interesting decision from the court. Okay, now what happened if the decision did not came out within the period specified in subsection 2? Then the whole adjudication is void, right? The adjudication decision must be made in writing and shall contain reasons why. Okay, and it must also determine the amount that is to be awarded to the winning party. Okay, and in what manner the amount must be paid to the winning party. Okay, and then the copy of the adjudication decision will be served. Okay, and then of course there is including if there's any error, it's just a typo error or something. It cannot be a change in the substance of the decision. Okay, and then yeah, and then the evidence act is not applicable in the adjudication. That means to say, unlike court will say that this evidence, how many percentage is weightage to this evidence and whatnot. So evidence act does not apply, but the evidence rule apply. That means how you look at the evidence applicable. Okay, the rules apply, but not the entire act itself. Okay. Now, in reality, okay, this thing happened. Okay, this is what we call the second bite of the cherry. That means to say, in reality, when the adjudicator actually close the adjudication and say that I need 45 days to come up with a decision, the respondent may submit another request. And what is this? The respondent may say that in the reply, new evidence has been tendered, and we do not have the opportunity to respond to this new evidence by the claimant. Okay. Therefore, Mr. Adjudicator, I write to you to seek for a hearing for this matter. How? As an adjudicator, will you say that, okay, let's go to hearing, I will set a date to hear this matter, or adjudicator will say that, oh, sorry, Mr. Respondent, the matter has been closed. Now is my time to retire for 45 days to come up with my decision. Can this happen? Now, this is another case, also very interesting. After the closing, the respondent quickly submit a request for the matter to be heard. Okay, and then of course the usual thing the adjudicator did was he said, sorry, I need 45 days to come up with my decision. I'm not going to entertain you. And surprisingly, the court decide that, you know, since the request was made quite early, there's no reason why the adjudicator must not actually consider this matter seriously. So this whole thing opens a floodgate, you know, to the rest of the disputing parties, you know, SIPA. It means to say, if the respondent give an early notification, there is a role or there is a need for the adjudicator to address and perhaps to even allow for hearing. But then, of course, there's another way to reconcile back, but I won't talk about this. Okay, this will be a further advanced session on SIPA. Okay, but you have to bear in mind this thing happened, especially during reply. The claimant actually throw in an expert report, for example. So suddenly, respondent was caught off guard. He took this expert report and said, "Oh shit, so many things inside there." So then I got no avenue to actually respond anymore. So therefore, I want hearing. This thing happened. So this is what we say the second bite of the cherry. That means to say it's still not over yet. I want to attack some more, or I want to respond some more. So this is in reality lah. Nowadays, all kinds of things happen. Okay, so this is an example. You put down there. Dear adjudicator, it has come to our attention that claimant has provided such and such authority that is finds to be inconsistent with the legal principle. Okay, now this guy attacked not on the evidence. Now he's saying he wants to attack on the terms of the legal principle. He wants to attack in terms of a legal argument. Okay. Yeah. I say that we request the adjudicator to allow the respondent to ventilate his case on the basis of points of law, not merits. Now it's a points of law. Having taken that the response is only our submission based on merits. As such, we plead to your gracious consent not to close the proceeding pending this submission on the point of law. The issue with regard to the point of law, we will state everything. And then we look forward to your further instruction if a hearing will be warranted. So if you are the adjudicator, suddenly you are caught with this kind of thing, which is not in this book. It's a special request like that. Will you entertain, or rather, how will you deal with this? These are the things that you are not being taught, but this thing happens in reality. Okay? So the question is to allow or not to allow. That is the questions that the adjudicator have to think about it. You allow, also got problem. You don't allow, also got problem, because there is a case law. So this is something that you have to consider. Now, assuming no further request, okay, assuming there is no further request, what is inside the adjudication decision? This is something that we want to explore. So what is meant to be an enforceable decision? A decision is enforceable when it fulfills the formal requirement. Now, what is this formal requirement? It has to be dated. The decision has to have a date, has to have a seat. Seat meaning to say is they call it a judicial seat. That means to say, based on what law to actually write this decision. So if the seat is in Malaysia, so the seat is in Kuala Lumpur or something like that. So this seat in this case has to follow the project site. If the project site is in Penang, the seat will be in Penang. So you have to put your date, then you have to put down the Penang. If it's Sabah or Sarawak, you have to put down the Sabah or Sarawak. Because there are cases. So if there is a dispute on your decision, if it is in Peninsula, that means to say the High Court in Sabah and Sarawak cannot hear this matter. You will have to deal with in the Malaya court. If it's on the Borneo side, then the Borneo court will have all the jurisdiction to deal with it, not the Peninsula side. So the seat is very important. Okay. Then all your decision has to be in writing, and you have to sign as an adjudicator. Okay. In your decision, you have to clearly identify the parties. Now, it seems very normal that I say identify the parties. I can tell you, for a very creative lawyer, even this meaning of identifying the parties can be a major issue. Okay, I will not say it more. Later, I will give you an example how this thing can turn out to be a big issue. Okay. Now, next, recital. That means to say, in your decision, there must be a background, preamble to the whole dispute, and then there must be a chronology leading to the appointment of the adjudicator. What happened before and what happened after. And then there must be a section on the contract and its component. And then there must be a section on the submission. That means to say, claimant submit this, respondent submit this, and then claimant reply this, all the submission. Then you have to raise the issues. That means the certain issues that the adjudicator wants to consider, usually in the form of a question. We always say that the five, what, why, when, and how. This kind of thing. These are called issues, And then you have to put down the reason. That means to say, you have to write the answer to the question that you ask yourself. Okay, so this answering has to come together with reasons and findings. All right. Then after that, after you have write everything, then you have to notify the parties. Sometimes we call this as publish your award. Right. So this is what it means. Okay, the decision is enforceable only when it has contingency, it has completeness, it has certainty, finality, enforceability, jurisdiction, blah, blah, blah. Okay, this sounds very foreign, but I will attempt to answer one by one. Okay, so this is generally how your first page of your adjudication look like. And these are the contents. Okay, and this is how we put in the parties, the section where the party is, the claimant is so and so, whether is it registered under the Company Act or something like that. Then the respondent is so and so, and the respondent is either represented or not represented. So you have to clearly state all these things. Okay, then the construction contract. Now make sure the parties has a local standard. That means to say the parties can represent themselves. Okay, and you have to tell party representatives has also the local standard to work on East Malaysia or in Sabah and Sarawak. There are cases, especially to lawyers, if you represent your client if you're registered in Peninsula, you cannot go over to Sabah Sarawak. But the Sabah Sarawak lawyers can come over to Peninsula. So you have got this territorial issue, okay? So this is what is. So this segment of the construction contract, you have to give the salient feature of the construction contract that is involved. The contract must clearly define the scopes and the payment terms. Okay. And then there is also the mandatory submission, for example, the payment claim, when you receive the payment claim, when you receive the payment response, and so on. Then after that, when is the notice of adjudication being made? When's the request for adjudication for appointment being made, and so on and so forth. Then the acceptance of the adjudication and the agreed terms. So all this has to be put into your decision. And then the other mandatory submission by the parties, like the adjudication claim, adjudication response, and reply. You also have to identify clearly when is the date that this submission was made and when is the date the submission received. Okay, now this is very interesting. There is argument onto the way documents are served. All right. Now, if you serve by hand, you take the document, you go to the opponent party, you say, Mr. So-and-so, I'm now serving you this notice. What happens if that person does not want to receive a notice? What happens? The rule states that if the other party do not want to receive, all you need to do is you take picture or photograph of the document properly handed to the other party during office hour. So your photo has to be dated, time, and it has to clearly showing that this is the office of the address that is supposed to be served to. Okay, and some lawyers will do extra. They will ask the person who make the serving of the documents to do an affidavit, a sworn testimony that this document has been made, in front of the in front of the commissioner of oath. So the testament will be attached together with the notice. Then it becomes extremely strong and valid. Now, alternatively, recorded delivery is by way of AR register post. You send the register post AR, there's a yellow card behind one. So once the other party receive, then the yellow card will be sent back to you. But then this AR register, what does the law says about this is this. It says that it will remain valid unless it is disputed. That means to say it's acknowledged to be received unless the person who received it dispute that he has ever received that. That's what it meant. Okay, so these are things that has to be considered when you do serving of notice and whatnot. Not just simply put your things into WhatsApp and serve the document or in email like that. So it has to be properly served. Okay, so now all these things has to be identified, especially the date. So sometimes you say the adjudication reply dated such and such, and receive dated such and such. You see, so the receive date and the date in the document sometimes can differ. So this is something to be considered as well. And then you have to the adjudicator will have to list down all the issues that the parties has raised. The adjudicator cannot answer an issue that the parties did not raise. So there's a word for the axiom for this. It says this: the adjudicator can answer the right question wrongly, but the adjudicator cannot answer the wrong questions correctly. Okay, so if the party got raised this issue, he can answer it wrongly, but he cannot answer the issue that does not raised by the party correctly. Okay, so in order not to be in that situation, he will have to frame his question very, very systematically. Okay, how you frame the issue, this is not only science, you know, if you done for many times, it become an art already. When I started off as adjudicator, I used to, you know, put a lot of questions. As I go on, 3-4 questions become 1 question. You can actually a way to actually coin the question in such a way it become 1 question that answer a lot of things. So this is an art, all right? So for completeness, the adjudicator will declare that he has taken all submissions served before him. This is to safeguard himself. Then he may put certain caveat. Sometimes he will amalgamate or bifurcate the issue. Sometimes the party may raise 2 issues, which is almost the same. You can actually join it together, or he can take 1 issue and then break it down into 2. Okay. He may declare his position that he may talk. Sometimes the adjudicator may say that, oh, I may do this or I may do that. Okay. Or he may list down all the other issues that a lot of newbie does, but seasoned adjudicator will just lump everything together and answer it as it goes on. Okay, so this is the certain strategy that adjudicator does. Now you must remember that what's the big reason of putting your decision into writing? Actually, you write the decision is for the sake of the losing party. The winning party just want to know the outcome only. If you won, so be it. He's very happy. He gave back his money. But then the one who lost the case will feel pain, you see. So he must at least understand how he lost to the winner. So the nature of the decision is to write for the person who lost the case. So you have to write. When you write the decision, you write on his stand on his shoe. The reason has to be stand on his shoe. You have to explain as clear as possible, so as to allow the aggrieved party to appeal to the High Court, or to allow the unsuccessful party to understand why and where did they fumble in their assertions. And in doing so, the adjudicator must let the party understand its modus operandi of the decision-making process, which means to say he must reveal how he make the decision, why he take a certain steps. It's okay. That's why I say it's okay to actually answer the right question wrongly, but you cannot answer the wrong question correctly. All right? So how to answer this? We always start with a question. Then you put forward the arguments by the parties, and then you proceed with to analyze. All right? So for example, start with a question. Take this as an example. Whether has the respondent the right not to pay the claimant? This is a question. So in the claimant's claim, he claims that he has done this work and he gives this invoice, he ought to be paid. But then in the respondent's argument, the respondent say that he did not complete his work. He only complete half of the work. How can I be paying everything? And then in response to that, the claimant say, oh, that is not right, because you never objected to the invoice that we serve. And you signed you also have signed the what you call the certificate of completion. So you have to take the argument into the picture, and then now you make your decision. You analyze the situation. Okay. So how do you analyze? First, you always analyze by the way of the law. Okay. Now, what did the contract say, or what did the law hold in this case? Okay. So you have to say, what does the law hold? The law says very clearly that if he has done his work, he must be paid. Okay, for example, this is the law. Very clear and very straightforward. Right? Then after that, you say, what the evidence show? Now the evidence show, oh, he has done his work. Sign off already, ma. Correct or not? So the evidence show that he has done his work. And then what did the contract say? The contract say, if this person can show that the consultant has given the certificate, is entitled to be paid. That is what the contract say. Okay, so then what is your conclusion? Therefore, after considering the law that says this, the contract that says that, the evidence that appeared before me to say this, therefore I find and hold that he's supposed to be paid. So the conclusion is very important. The conclusion is where it gels everything together and make the decision. Okay? So the declaration is important, where the conclusion is. For example, to hold where the liability falls is of paramount importance, and it must be consistent with the findings. Move to contemplate another issue with the same models of conduct. That means to say you do this for this question and do it for another question, another question, another question. This is consistent. You do it that way. You will not get wrong. That means to say for this issue you make a decision like that. For that issue you make a decision like that. For the next issue you make a decision like this. So overall, you see the balance of probabilities. Okay. If there are more decisions in favor of the claimant win. If there are more decisions in favor of the respondent win. It's very simple. It's just balance of probabilities. Okay. So after you have assigned liabilities already, you go to allowed claim or you dismiss claim. This is the only two outcomes. Okay. You cannot say 50-50 the kind of situation. You allow claim or you dismiss claim. Okay. So if you allow claim, you just say that I find and hold the respondent is entitled only to this amount. You can then you can look at the amount. The amount may be 100%, but then you may say that, oh no, he only entitled 50%. Things like that. Okay, so the first example is where the respondent is successful. The second example shown here is the claimant is unsuccessful. I hold and that the claimant is not entitled to any claim whatsoever. So this is the outcome. Okay. Okay, there are basically two outcomes. One is allowed claim or determine the quantum, and the other outcome is dismiss claim. So if you allow claim, you have to determine how much to be paid. So you have to say that, oh, this is the amount claimed and this is the amount awarded. Okay? They do a table side-by-side analysis. Okay. Then you have to award interest. Okay, you have to award interest, and then you must make sure that to say it. Sometimes parties may say that they want this X amount of interest to be calculated from this date. Okay, now this is where problem will come in. If you look at the FAM contract, it says that the interest is based on the Maybank base lending rate, right? If the parties ever claim that contract, would the adjudicator award based on the Maybank interest rate? The one who actually most lawyer will not allow. The reason is very simple. If we say that the interest occur based on the Maybank interest rate, you have to prove, you have to show documentary proof that actually the interest happened based on the Maybank base lending rate. If you fail to prove, that means to say adjudicator got the right to say these are all bullshit. I don't allow. That's why there's a safer way. Usually what they do is that they ask for interest, but then they allow the adjudicator to decide how much interest. Then on the safe side, the adjudicator will based on the court ruling, and based on the court. So the court say 5%, 5%. That's how it works out to be. So, but the thing is then, when it's going to be paid, that is something can be adjusted. There are two kinds of interest. One is called pre-award interest and the post-award interest. Pre-award interest is like the invoice you are given already, but then it takes so donkey years to come back to you, correct? So haven't even go to the adjudication. So interest has already been counting already. So this is called a pre-award interest. Post-award interest is when after the decision has been made, you still need some time for the party to pay off, and this interest offer is called a post-award interest. So party has the right to claim for interest. The winning party has the right to claim for interest, and the adjudicator will have to decide. Okay. Not only that, the adjudicator has to decide the party-to-party cost. Remember, I said just now, some party may engage claim consultant to do the claim for them. So there's a fee payable by the claim to the claim consultant. So the winning party will claim back this fee from the losing party. This is the meaning of the term called cost follow event. That means that the one who lost have to pay everybody. Okay, so these are something. So sometimes as adjudicator, not me lah, and some other people have been talking about this. If they find that they are not being given the recommended fee, sometimes they will deduct that in the cost of the claim consultant or the lawyers. Not very good practice, but it happens. Okay, so in your decision that you have to determination is very important, that you have to say who is paying who and what is the sum, when. Then who is paying who, the interest, when is it being calculated, where and what basis. Then you have to state very clearly the cost incurred for this adjudication to be paid, when and where to be paid. Okay, so if you don't state this in this chronological order and precisely in that way, during examination you fail. This is very important. Okay, why you fail? Because the whole adjudication award cannot be enforceable. It will be thrown out. Okay, so this formality of this is very, very important. And remember always to date and to sign. If you've forgotten to sign, also you'll be thrown away. Okay, and the seat has to be there. For example, in this case, in this example, signed by myself, I'm the adjudicator, and the state is in Selangor, Malaysia. This is the seat. Okay, dated is on top. They dated this. So this format, once it's there, then this is what the adjudication decision looks like. This is what we always call this operative part of the decision. Whatever earlier that I mentioned just now is the interlocutory part of the decision. Okay. Substantive requirement. That means to say what are the items that need to be inside the decision to say that it is enforceable. Contingency. Remember just now I said I will explain this in further. The meaning of contingency is persuasive reasoning. Example, all men have beard. Okay, assume this is correct lah. All men have beard. Then Aristotle is a man. Therefore, he also must have beard. Correct or not this statement? So nobody can say this is wrong. Because you qualify yourself by saying all men has beard. And Aristotle is a man, right? So he also must have beard lah. Okay. So this kind of persuasive reasoning has to be there, logical. And in order to actually sustain that, usually we always say, the law holds this and this and this and this. The contract says this and this and this. And this. The evidence pointed to this and this and this. Therefore, my conclusion is this and this and this. And this. Okay, these are the way we write for persuasive reasoning. Okay. Completeness. That means to say all matter raised by the parties. Example, all the matter raised in the claims, the response, and the reply. And if there's a hearing, everything is raised in the hearing, as the case may be. You don't leave anything. You don't leave no rock unturned. If the matter was raised by them, record it down. All this matter has been raised and address it. Okay. So sometimes in the conclusion, we do it in a stylistic way by saying that now having considered all submissions. You have this statement that means say you already declare that you have looked through all the submissions. Whether you really look through or not, I do not know. But then you tell everybody, the whole world, saying that I have already considered all the submissions by the parties before me, and on balance, I find, oh, this is my decision. So you cover your backside, people say. And there must be certainty. That means to say there's no ambiguity. You have to say, I find and hold. Certain, I find and hold. I find, not only you find, you hold, pegang kuat, that kind of thing. So you find and hold, okay? You find and hold what? Who is to pay who? You have to be very clear. This person may pay to this person. Cannot do that. You say, this person pay to this person. No may, no shall, this person pay to this person. Then clarity, how much he has to pay, when he's going to pay, and in what form. Balance transfer, credit card, cash, you have to tell. Okay? And then you cannot say that I ought to award. Ought tak boleh pakai. You have to say I award. Tak boleh say, cannot say that I may be award. No such thing. Okay, so it has to be certain. You cannot have ambiguity. Finality means your decision has to be unconditional. Means to say nothing is left undecided. All right, and avoid things like subject otherwise to this and this. This kind of wording must be thrown out. Cannot. Subject. When you say subject otherwise, this means it's conditioned upon. Okay, you cannot have all this kind of thing. Okay. Enforceability, that means to say it has to be enforced. Application, this act applies to every construction contract. This is enforceability. And non-application is natural person, the false story. This is cannot be enforced. Okay. Then jurisdiction. Okay, power of the adjudicator. What does the adjudicator have the power for? He has the power to establish procedure, the power to order discovery, the power to address deadline and production of documents, and the power to draw on his own knowledge and expertise. This is very important. Now, there's also danger lurking on this line of argument. Draw on his own knowledge and expertise. You see, a lot of these adjudicators are actually technical people, QS, engineer, architect. But can you make a decision by simply saying, I think, therefore I am? You can't. If you think certain thing that based on your knowledge, you must let the party know that, okay, gentlemen, from my experience, I find that this is how it is. And you must give the opportunity for the parties to think about it and to argue about it. Okay, the party may say, okay, thank you, Mr. Adjudicator. I know that this is where you're coming from. This is what you think it is, but we may think differently. Why the reason is like this? You must consider their reasoning. Then the final say is still with the adjudicator. After considering what you have to say on this matter, I find no substance in your argument, for example. Then it is fair. That means at least you give the chance for the party to argue. You cannot just jump into conclusion and I am God, therefore what I think is correct is correct. No such thing. Okay, even though you are extremely experienced and you are the experts in this field, you can't do that. So drawing on his own knowledge and expertise has to be taken with a huge pinch of salt. As long as you give a chance for the parties to argue, then it's okay. If not, it's not okay. Okay? All right. Then the adjudicator can also appoint independent experts to inquire and to report on the specific matter. So far, I don't think a lot of adjudicator does this. No adjudicator will want to go an extra mile to actually get independent views on certain things. Okay. Now, adjudicator can also call for meetings of the parties. All right. But again, we would like to just deal everything with documents. Why? Because we are just pay this fee. Unless party agree to pay you by hours, then the story will be different. Okay. Sometimes you can also conduct hearing. If the party willing to pay, why not? And the party must also willing to give you extension of time. Yeah. And this also apply to carry out inspection on work. Inquisitorily take the initiative to ascertain the facts and the law required for the decision. As long as this thing is mooted by the parties, if it's not mooted, cannot. You issue direction that may be necessary for the expedient of the adjudication, yes. order interrogatories to be answered. Yeah, sometimes you just have to seek the party's view on certain things. Yeah, you can do that. Order that evidence be given on oath. This is for hearing. So if you have hearing, then you have to be ordered on oath. Okay. Next, legal. Oh, there's some more. Review, revise any certificate issue. Yeah, this is what you ought to be doing. Decide or declare any matter notwithstanding no certificate has been issued in respect of the matter. Award financing costs and interest. Extend any time limit. Okay. Now, jurisdiction in relation to dispute limited to matter referred to pursuant to section 5 and 6. That means to say he can only have jurisdiction to deal with the matter raised in the payment claim and the payment response. Everything outside payment claim and payment response cannot be considered. Therefore, it's very important in the adjudication claim and the adjudication response is always refer back to your payment claim and payment response, not something outside of it. Okay. But then there is this problem. This is a very interesting case called view esteem. In this case, it appears that the respondent have a bigger opportunity to have a second bite or third bite to the cherry. Now, let us say that he did not give a payment response and he decided in the adjudication response to throw in the whole kitchen sink. Like in subsection 2, it says that you cannot consider things pursuant to section 5 and 6. You have to be within section 5 and 6. But suddenly in the adjudication response, the respondent throw in the whole kitchen sink together with all the plumbings and whatnot. Can that be workable for the claimant, especially he has only 5 working days to give a reply? The position of the federal court is, in view as Steve says, that yes, the respondent has the right to defend himself all the way. Therefore, whatever reasons that he has not raised even earlier, he can also raise it now, or he can even raise it thereafter. So this becomes a very contentious issue for adjudication and difficult to mitigate at this moment. Okay, and usually when an adjudicator is confronted with the fact that his jurisdiction is being challenged, he will usually say this. Okay, he will usually say this, subject otherwise to all the challenge under section 15. I have the right to continue on with this adjudication. Okay, so in court, the adjudication can only be challenged in a very narrow manner. Number one is that the adjudicator had acted beyond its jurisdiction. Number two is that there is bias, there is all this kind of thing. But this has to be proven. So within a very narrow ambit, you can actually challenge the decision in court. This is where legality comes into it. Improperly procured adjudication decision, which means to say it by fraud or bribery, is a denied natural justice. For example, you are not given an opportunity to raise concern, not given the opportunity to argue. So this is the meaning of denied of natural justice. Or the adjudicator has acted not independently or impartially. For example, he has unilaterally meet up with the respondent, for example, or meet up with the claimant without the knowledge of the other party. Happened. It also happened in my case before. That will be another story for another time. Or the adjudicator has acted in excess of his jurisdiction that I mentioned before. So all this considered as illegal. So the question of legality comes in, the decision will be what? Possibility. Stay of the adjudication decision. That means to say the adjudication can be put aside. All right. Why did the adjudication put aside? because it can be due to application under Section 15, like just now I mentioned just now, the whole long list of things. Or it can be because there is a final determination by an ongoing arbitration or court decision. So that's why you find that in, for example, in PAM, there's a lot of arbitration that seem to be started but did not continue. Because parties just want to start an arbitration and then decided to actually put a stay on the adjudication decision. Thereafter, they go and have their good time, argue somewhere else, or maybe settling the case. This is just tactic to delay, delay one party from paying the other party. Okay, so the High Court may grant the stay of the decision or payment of part of it and make any other order if it thinks fit. Okay, so this is a wider discretionary limit for the courts to decide. Your decision has to be consistent throughout. Okay, what does it consistent? That means on the top you say like this, bottom also must concur what you say on the top. You cannot have something that's inconsistent. And avoid using word like perhaps. Okay, perhaps this is inconsistent. Don't use this kind of word. All right. Compliance with submission. That means to comply to all the formal requirements that I have just said just now. Okay, so we do a recap. What I've said is now, after the 10 working days, you receive the adjudication claim. The respondent will submit the adjudication response. Then thereafter, another 5 working days for the claimant to submit the adjudication reply. And thereafter, 45 working days, the adjudicator to come up with a decision. All right. There is something called a post-decision. Never think that after you receive the decision from the adjudicator, everything is there. That is only the first part of SIPA. The post-decision is the second part of SIPA that comes after you have the decision in your hand. What are you going to do with this decision, right? Now, once the decision is rendered, that means the decision has been written and it has been published, or notified to that party. The adjudicator is functus official. Functus, not fungus. Functus official means to say the official mandate for the adjudicator to act has expired. You got no jurisdiction whatsoever. You can't call him back to argue your case again. No. Once the decision is issued, that's it. His work is done. Now, in such, can I consider it the end of the adjudication? The short answer is no. No. The short answer is yes. The adjudication is ended, but something new starts. The long answer is the beginning of the court drama. So once you receive that, what happens next is one party that is favorable, the decision find favorable, will take that decision to be enforced in court. The other losing party will try to take the decision and set aside. So this is what you meant by court drama, because this thing had to happen in court. Okay, and after you get the decision, you need a lawyer, because everything to deal with court, you need a lawyer. So for enforcement or of setting aside, so there's only two possibilities. So enforcement is to enforce the adjudication. So once the court has been made the order of enforcement, it's as good as a court judgment, high court judgment. Or it can be suspension reduction on the. Now, once you have the enforcement, the aggrieved party can actually stop work on site, or it can reduce their work on site. And if it's a subcontractor, he can claim the money from the principal. That means you don't have to claim the money from the contractor or the main contractor. You can claim from the principal. That means to say the employer. Okay, of course, there is also a way to give notice for what we call suspension of work on site. And this is what it meant by once you pay off, then you can resume back your work and so on and so forth. Direct payment from principal. That means that for the subcontractor, you can get your money paid if you win the SIPA award from the principal if the main contractor has got no money to pay you. Okay, but then this entails another problem. This is all legal problem that the lawyers created. Okay, in reality, the war is far from over. Now, this is a case. Let us talk about this case and see how is your response. You can answer this in your questions. This case happened in 2022, S versus M. I can't disclose the party. So S mount a SIPA against M. M did not appear as a respondent. M very quietly, yam. So SIPA proceeded ex parte. Ex parte means one-sided. Because I told you SIPA is to continue on. Okay, so without the respondent. And then, of course, without the respondent, the decision rendered in favor of S. Okay, and then S proceed to enforce the award in High Court. Then also the M did not appear as defendant. Wow, interesting. Even in court also M did not appear. Okay, but then M go to High Court to make a claim against S. So High Court made an order against M. And M did not take any action whatsoever. Okay, this is very interesting. So what do you think S should do? Any answer? S proceeded to blacklist M with CITOS. Okay. Now, after the M got blacklisted by CITOS, now M start to take action. Very interesting. Instead of anything, M sue S for wrongful action, for wrongful obtained the adjudication decision under two grounds. One, M has S has got no locus standi to make a claim against M. Number two, S action with regard to CITOS has caused embarrassment. Now the sue is under the top. It's beyond this normal construction claim anymore. So it becomes a full-blown legal case where the unpaid party now becomes a victim. It's real. This case is very, very real. Okay, so now we do another recap as to what happened after you get the decision. All right, you either go for enforcement. If the court give you enforcement order, it's as good as a High Court order to pay. It takes around 3 months, sometimes. Fastest is around 3 months. If you are not able to get the enforcement, that means to say you go to full litigation and arbitration. And the matter is in there. And then after you get the court order to pay, the question is whether the payment is made. If the payment is made, yes. If no, you still go to litigation and arbitration. And the matter is there. So this is the whole journey on SIPA. Okay. Future forward. Now we look at what is the issue with SIPA. SIPA, like I told you just now, the one of the case S versus M, SIPA has lost its purpose. It's now like there are certain clients of mine who say that no, it's not a question whether I receive money at the end of the day. It's a question I get a decision in my favor. Yeah, there are people who like that. Because once they get the decision in their favor, and this matter goes to court, they can register themselves as a debtor. So if this company Gulong Tika, they at least have some local standard to claim back their money. So they want the decision, even if it's temporary finality. Okay. So SIPA has become very over legalistic. Just now I told you all the court cases you can see is lawyers are very creative. They can come up with all kinds of defense, all kinds of things that derail the entire mechanism of SIPA. So it becomes something very over legalistic. And it becomes like a winning on paper only. In substance, you may not get paid. Okay. So what the future beholds, you can download my writings over here. You can take a picture on this and then you try to download. So I have shared my view as to what future CIPA will take its form and what are the issues together with all the related cases that I mentioned just now. It's all there. Because when you write articles or journals, you tend to put more information. It's more of a research work, so you can read that. Okay, please download from here. Okay, I think I've covered most of the thing. I open up to any question and answer if there's any. Shall we?
Okay, thank you, Architect David Ye, for finishing very early. You're very efficient. Anyway, okay, we do have questions in the chat box. David, can you access the chat box?
Okay, I need to access the chat box. Okay, let me see how to. Okay, the chat is here. How many questions are there?
At the moment, let me have a look. Currently, there are 2 questions. So to all participants, we have about 40 minutes for Q&A session. So if you have questions, you can type your question in the chat box. Because I could only get Architect David Ye like once a year. He's a very busy person. So please type your question if you have anything about ADR or whatever related to the topic that we discussed today. Okay, David, can you see the first question?
Can I know if CIPA applies to variation order work as well? If yes, does CIPA apply if there is a dispute on the amount of variation order agreement after the work is already there? Okay, like I just mentioned just now, you read the act itself, it connects with all payment method, and variation is also considered as a payment method. So if you have a variation, yes, you can mount a CIPA against them, but then you must remember, usually adjudicator will not put his neck for you to chop. So even if there is a variation, as long as there is a certificate that certifies that variation, then highly likely that you'll be awarded the variation. It's not very difficult. Okay, so this is one thing. If yes, does CIPA apply if there is a dispute on the amount of variation order agreement? Is there a variation order agreement? I think most of the variation is just a clause in the contract. If it allows variation and that variation can be proven and also be certified by the respective consultant, then I don't think there's an issue. Before CIPA, there is mediation. How is the mediation take place before CIPA? No. CIPA is a statutory order. It's not a statute order, sorry. CIPA is a law, okay? Mediation is not a law. That means to say you cannot contract out CIPA. If one party takes against you using CIPA, you have to answer to that party because it's law. You cannot even have a contract to say that parties agree not to take action against each party in CIPA. You can't have this clause because CIPA is a law. There's a problem with the PAN form is that there is a contractual adjudication. The question is unclear if there is a party that do not want to go to this contractual adjudication, even though there is a clause in their contract and he has consented it, CIPA still take precedent. Okay, you cannot take away CIPA. And mediation is a consensus agreement. That means if both parties agree to mediation, whether you do mediation or you don't do mediation, it should not be taken as a condition precedent to adjudication. Which means to say party can at any one time, even though there's no clause in the contract to say that one party can take CIPA against the other party, anyone can do CIPA. Okay, so CIPA, because CIPA is a law, mediation is not a mandatory law. It's only through party consensus. Okay, can the adjudicator seek clarification from either party without the other party knowing? Cannot. You do that, this is what you call unilateral communication. Okay, whatever decision rendered by the adjudicator will be void. You cannot do that. Okay, But I have one case where the adjudicator does this. We also have seen cases where the adjudicator actually went to the party's office. So all kind of things can happen. All right. Let's say median project of shop houses, landed houses with 2 stories is not under scope of SIPA. Yes. Because of the story, it has to be 4-story. Okay. And then okay, now this is very interesting. Okay. You have got the 4 conditions, right? This 4 condition does not stand alone. That means to say, it's not to say that you breach one of these conditions, therefore you cannot SIPA. No. All the 4 conditions must be read together. So if this is what, if let's say a 2-story project houses, okay, it's a project basis. The what you call the thing is a housing scheme or the shop lot scheme. It still can be SIPA. Okay, because the whole intention is to sell to somebody. It's a commercial related item. It's not for a personal use. You have to understand that point. Okay, the argument comes in only if the thing is for personal use, and yes, it is less than 4 stories. So all the item has to be ticked. Then only you can say that it does not fall onto SIPA. Okay. There is a specified numbers of notification needed to be issued before SIPA can take place. There is only yes, notification means to say there must be a payment claim. Then there must be a notice for adjudication. Then subsequent all those other submissions. You follow all the prescribed section 5, 6, and so on and so forth in the SIPA Act. Yeah, there is quite a number of notification to be made. If company A terminates the contract with company B, but company B still owes subcontractors company C, company B now being terminated, can company C mount SIPA against company B? But company B proclaim they are also victim. Oh, very confusing, this one. Okay, when a company when the contract get terminated, you still can go for SIPA, no issue. Okay, so subsequently, whatever subcon that is involving in all those conundrum can also mount, because as long as it is related to payment claim, you are not claiming on the substance that you being terminated. You have to make it clearly. You cannot make a claim because you are being terminated. You make a claim only because there's an amount still owed to you, which is supposed to be paid. So it already depends on how you strategize your claim. If you claim that you are wrongly being terminated, that cannot be dealt with in SIPA. You have to deal that in arbitration or the litigation. All right. Similar to all those subcon issues. Does construction consultancy service include QS services? Yes, it does. According to the first schedule of SIPA, all the water infrastructure projects are exempt from SIPA. If a case arises related to this project, what actions can be taken? Well, you just have to do arbitration and whatnot. This water infrastructure project, I need to get clarity as to what this water infrastructure projects that is that you are referring to. Yeah. Then the next thing is sorry, where am I? Construction industry in the law currently more for buildings. How about railway industry where the client is government-related infrastructure? Yeah, railway is also construction, especially with now the China contractor that comes in. There could be a potential dispute on that as well. Previously, whenever government contract, you cannot SIPA, but now this requirement somehow has been taken a more liberal view. Okay. For warehouse, single-story factory is less than 4 stories, so does mean SIPA. Like I told you before, if you develop the whole entire scheme of warehouses, okay, like what some developer does, only 2 story, but all warehouses were meant for for people to buy as a, it's a project scheme. That one can be are able to do SIPA. What cannot be done is if it has to comply with all the 4 criteria. One of the criteria, if it's on its own purpose use, then cannot. So either one, if one drop short, you still can apply for SIPA. Halfway of the construction, both parties went into SIPA. Does the unpaid party have the right not to perform any work? Only when the decision has been rendered and to his favor, then you can stop work. If the contract has got this provision, you cannot simply stop work. Even the contract has this provision, sometimes to stop work also is very dangerous. Why is it dangerous? It will be another discussion. But the provision of the law is very simple. You can stop work only when the decision is in favor of you. Then you can stop work, because SIPA is a law. SIPA says that you can do it that way. Okay? Any other question? I think I cleared all these questions already. Did I miss any questions?
I think there's one question at the beginning from IR1 Latif. Notice or request, can it be sent through WhatsApp?
That depends on how you define in your serving of documents. Okay, there is a provision in the serving of document. It has got a few ways. If parties agree WhatsApp to be a mode of serving of document, by all means do WhatsApp. But usually WhatsApp, in law, we don't usually do that, When something as important as that, we usually use the AR register or we use it by hand. Does construction consulting service include QS services? Yeah, I already said yes, it does include QS services. Okay. Anything else that I missed? Single story warehouse design. Yeah, if it's a design scheme, it's not just one unit. It's like the whole estate for the warehouses. Yeah, then you can do the SIPA. Does it applicable if consultant to refuse to give design input while still in construction? Consultant can be SIPA. Does it applicable if consultant to refuse to give design input while still in construction? Consultant can be SIPA. Usually, it's the consultant that SIPA the client. It's not the client that SIPA the consultant. Any commercial building, no matter how many stories SIPA can take place. Yep. The purpose is for commercial only. It's not for own use. Yeah. Hey, we still have half an hour now.
Yeah. Okay, to all participants, they still have questions to Architect David. Yes, you can type your question in the chat box. We also have participants who will be sitting for the PCE examination. That one is for the professional engineers exam lah. And those architects are graduate architects who will be sitting for LAM Part 3 this end of the month. So if you have questions about ADR, adjudication, or even arbitration, okay, I think Architect David are able to also answer the questions about those. Okay, please feel free to type the questions. We still have 30 minutes. Banyak lagi masa nak tanya soalan. Okay, there's a question from Mike. David, can you see the question?
If subcontracts ID works applicable for SIPA. At this moment, ID work is for subcontract, yes. As long as it falls under the nature that is commercial. For example, this is related to hotel. Yeah, okay, hotel, you got interior design, right? For example, and then this interior design usually done by subcontractor, correct not? And then main contractor for the building already got issue. Definitely subcon is not going to be paid. And now the subcon is mounting SIPA against the main contractor. Yes. Can you repeat on the 4 criteria eligible for SIPA? Okay. Let me go back to the screen again. Okay. The Act says that this Act does not apply to contract entered into by 1, 2, and 3. That means to say these 3 things must exist. Therefore, it cannot apply. You understand what I'm saying or not? These 3 items must fulfill, then it cannot apply. It's not to say that it will not apply. Either one of these is not fulfilled. This is something very, I mean, this is the finding of the courts. Some people may disagree with this, but then what to do? That is the argument. Okay. Okay. Where did I stop this now? Okay. Can you repeat on the 4 criteria eligible? Okay, this is here. Sorry, just want to clarify my question just now. Just now you mentioned that factory works for self-use is not under SIPA. Does that mean engineering consulting service also not included in it? If your engineering consultancy for that matter for a single, let's just say I built a bungalow. This bungalow has got multi-story building, multi-story level, and because this is not for the purpose of commercial, it's only for one person. As the architect, and this guy did not pay me, I cannot take SIPA against him because the criteria has to be fulfilled in totality. Okay. Same with the engineering consultant firm in that case. If there is a 2-story building, while first story will be owner use, while the second story claimed to be commercial use, can SIPA take place? These are contentious issues. I've not seen this kind of case before. Perhaps you can try, but in the general consensus is that the natural person, the less than 4-story high, and the intended for its occupation, these 3 things must exist before you can say that the Act does not apply. That is what the official definition. Okay. If we are working as a sub-consultant under the main consultant, and the client default on payment, causing the main consultant not to pay us, can be filed. Yes, you can. In what situation will the claimant goes to arbitration? Okay, as long as you have an arbitration clause in your agreement, then the court will require you to go for arbitration first. And whether you go to arbitration or litigation, it can happen together with SIPA. Okay, SIPA, when you take SIPA action, doesn't mean to say you stop going for arbitration or litigation. Both can go concurrently. I'm still not clear when to go for arbitration and when to go for adjudication. Could you kindly explain? If I were to give you my opinion, you can go concurrently. That means to say you can SIPA, then after that, you submit your notice for arbitration. Okay, you can do this concurrently. You don't have to wait one against the other. Okay, what if my client is building a 1-story warehouse for his own use? Cannot. You do that as long as it's for his own use. It cannot be SIPA. Back-to-back payment, is it contravene SIPA? Yes. Back-to-back payment. Okay, now this back-to-back payment is also very interesting. This is called conditional payment. Pay when paid. Okay. this is not allowed in SIPA. That means to say it's illegal to enforce this clause of a pay when paid. But then now people are very creative when they do the defense. They say that no, in our contract we never say that it is pay when paid. We only say that paid when certified. So can paid when certified construe as a conditional payment clause? The court interpretation is not. It is not a condition payment clause, even though the payment can only be paid conditioned upon the certificate is being issued, right? But then the position of court said no, this paid when certified is not construed as a conditional payment clause. Therefore, paid when certified is enforceable. Okay, so to be clear about this, back-to-back payment. Okay, is quotation considered a construction work contract, or must be PEM or a subset of PEM or JKR? No, a construction contract can be in many forms. It doesn't mean to say it has to be a PEM form. PEM form is called a standard form of building contract. It's standard. Okay, it can be a bespoke. Bespoke, that means to say you draft it on your own. Sometimes I get cases whereby the contract is just a fee proposal and then signed back by the opposite party. That means that both parties agree on this what you call fee proposal. Then there's already a contract. Okay. What's the ultimate power that SIPA has, which will enable the unpaid party to receive debt from the non-paying party, I guess, blacklist to CITOS, etc., etc. I think the question is how to force the unpaid, the non-paying party to pay after getting the decision. I think one way that we contemplated is to use CITOS to blacklist, so you some kind of rather force the person to pay you up. Then, of course, the other more drastic position is to wind up the other company. But then this decision is quite unsettled at this moment because there was one court decision to say that the decision of SIPA is as good as the court decision, therefore can be immediately enforced to serve the petition of winding up. But then on the other decisions, it says that no, SIPA is just temporary finality. You cannot base on your SIPA decision to wind up another company. So it's still unsettled at this moment. Okay, is a contract that is not signed qualifies for SIPA. The contract did not say signed or unsigned. The contract says that what qualifies as a written contract. It has to be written. It has to be acceptable. That means to say there is a form of response. Like just for example, there's an email that's sent out. Okay, this is the draft contract for your acceptance. Then the other parties reply to the email saying, okay, we accept wholly the draft that you have prepared. That also can be considered as acceptance. So this kind of situation does arise. Okay, so whether is it signed or unsigned for the contract, we still based on the principle of the contract law. Okay, if contract law 1950 says that all contract has to be signed, then it has to be signed. But then for application of SIPA, it has to be written. There must be some kind of reference to that contract that has been written, not verbal contract. But in the general law of contract can be verbal. Okay, so there's a difference now. Any question? I mean, pass back to you if there's no other questions.
Okay, tak ada lagi soalan Betul dah tak ada soalan ni We still have another 15 minutes. Okay lah, Architect David, before we end the session, would you like to share to everyone lah about those people who are reading the act itself? The language is a bit difficult to understand, especially those who are not familiar with ADR at all. So what is your tips in reading this particular act, even the Arbitration Act 2005? Speaking from your side point of view lah.
Arbitration Act is there is a amendment to the Arbitration Act, but the arbitration is an entirely different creature than adjudication. Okay, arbitrator has got this thing called they call it the arbitrator has the right to decide on his own jurisdiction. Adjudicator don't have this. Adjudication jurisdiction is all within that little small book here. They cannot create their own jurisdictions, but arbitrator can. So there's a big difference, you know. So a lot of things can be resolved in arbitration, but not adjudication, especially the things that is not related to money one. For example, extension of time. For example, LAD as a claim, not as a defense, as a claim. Expansion, loss and expenses as a claim, not as a defense. You see, so these are the things that can only be reconciled in arbitration, but not adjudication. Okay, for whatever purpose, even final account should be rightly be dealt with in arbitration. But now adjudication can do final account. You can imagine 45 days do final account, crazy. Don't make sense, you know. But then because the decision by CIDB at that time, Mati also want final account to be adjudicated. So dialogue, a lot of adjudicator when come final account, 45 days they will ask party A can extend 3 months, 4 months, 5 months, you know. Because when you do final account, you got to deal with expert reports, you know. Quantum reports, this kind of thing. Masa nak buat 45 days. Though architect and engineer, you know lah, final account, bertahun-tahun pun tak close, betul tak? Correct or not? Because the party simply doesn't want to sign the final account. How to close? And then suddenly 45 days have to deal with final account. Boleh. Okay, how does SIPA apply to unforeseen circumstances? Past COVID years in Malaysia, do they evaluate it? COVID punya cerita, as long as it's related to payment, yes. But if it's related to loss and expense, tak boleh. Why? Because loss and expense, this has to be proven. These are something called loss. It has to be proven. This has nothing to do with money owed to you, claim. For example, I owe you $100. This is money rightly to be in my pocket, you owe me. So this is called monetary claim. Whereas, because of COVID, I lost another 200 ringgit. Now this is loss. So loss cannot be dealt with in SIPA. It has to deal with in arbitration or litigation. Okay, so this is something you have to understand. Okay, any other questions?
Okay, all right.
Can I ask favor from IME to take? I mean, you switch on your camera as a memento for me lah. You take all pictures, everybody smiling face. Boring saja tengok muka I dengan IME saja.
Okay lah, boleh lah. Okay, whoever is would like to turn on their camera, please do so. Boleh.
You have to turn on to, you know. I mean, you take picture from your side there.
Okay, can.
If you have any question, you can just write in. I will try to answer as well. Kita ada masa lagi.
Okay, sekejap ya. Oops. Wait, I would like to stop share this one. Okay. Tak ada orang buka kamera pun, kita aja, David.
Ya.
Okay, ada yang buka kamera. Okay. Bukanlah kamera semua orang. Architect David would like to have a picture with all of the participants. Okay, sekejap saya ambil gambar. Okay, sekejap ya. Let me take photo. Okay, ready everyone? Because there are a number of slides for me to take a picture. So I'll take a picture one by one. Okay. All right, I'm going to take more picture. Hold on, baru the first slide. Okay. Sekejap ya, saya tukar next slide. Okay, ready everyone? Okay, 1, 2, 3. Okay, next one. Banyak slide ya.
Banyak slide 17 loh.
Okay, bear with me. Kita masih ada masa lagi. Okay. Okay, next slide. Okay, 1, 2, 3. Okay. Next slide. Okay. 1, 2, 3.
You can actually do the together mode. Everybody is there.
Tapi gambar dia kecil lah.
Kecil pun boleh lah. Asalkan
Kecil boleh?
semua.
Okay, sekejap.
Tak payah ambil beberapa kali lah.
Okay.
Okay.
Alright. Okay.
Alright. To everybody who take the exam, good luck to you. Professional exam, right?
Okay, so I would like to thank Architect David Yap for today's session. Thank you so much, David, for your sharing. Very clear as usual, and very precise in answering. So hopefully next year, if you are about to do this session again, I would like to invite you again lah. If we are about to do IR 2025 next year, okay. And to all participants as well, Architect David has already shared his website davidyet.com just now. So if you have any further would like to communicate with Architect David, yes, you can through the contact that he has shared just now. And to all participants, make sure that do not forget to sign out. The admin has already shared the sign out link in the chat box. Also, the QR code on the screen. Do not forget to sign out. Session number 18 of IR 2024. Tomorrow there will be no class. Session 18 will take place on the 29th of September. 29th of September. So tomorrow no class, next week also no class. 29 September, because I know that this week, the whole week next week, many people will take leave, confirm one. That's why next week there's no class. On the 29th, session number 18 will be on the Water Services Industry Act 2006. And then the last session will be on the 5th of October. It will be on Gas Supply Act 1993 and the Electricity Supply Act 1990. Okay, all right. Thank you so much, everyone. So I will see. Oh, ada tulis the sign up form is not open. Kejap saya bagi tahu admin. Admin, can you please open the sign up form, please? You should be able to do that shortly. Sekejap. Saya check. Okay, the form is already open. All right, thanks so much, everyone. Thanks, David, and happy holidays. Selamat Hari Malaysia. See you all on the 29th of September. Bye.
Bye-bye. Good luck. Bye-bye.